course.
So good afternoon, everyone. I hope you all are doing well. My name is Amit Singhal, and I am going to coordinate here today for this session and as well as for the rest of the session of this capacity building program. This fourth session of day 3 is going to have a 45-minute lecture, followed by a 15-minute slot reserved specifically for the discussion and question and answer session. For this fourth session, we have with us today Professor Tom Ellis. Professor Tom is a principal lecturer at the Institute of Criminal Justice Studies at the University of Portsmouth in United Kingdom. He is an academic and consultant researcher with 30 years of wide experience. His areas of expertise include Japanese and Korean criminal justice, youth justice, prisons, prostitution, and race, diversity, and criminal justice, where he sits on the Ministry of Justice's Race Statistics Advisory Board. Until the year 1999, he worked for the Home Office Research, Development and Statistics Directorate, and he also had a 2-year spell at the United Nations Inter-Regional Crime and Justice Research Institute, which is based in Italy. Professor Tom is going to address all of us for this session on the topic of crime control or due process. Before giving the floor to Professor Tom, I humbly request all the participants present here to please switch on your videos. Sir, we are happy to have you here. And now, without wasting any further time, I request you, sir, to deliver the lecture and address the gathering present on this virtual platform.
Thank you very much. Well, hello from Portsmouth. It's not that warm, but it's not raining. So this is a bonus in our conditions. Most of what I'm going to say is largely covered in this book. I'm not just pushing this book because we wrote it. We wrote this book because there were a number of reasons, but the students were struggling with putting all the issues together and getting a hierarchy and thinking critically. So it's mainly the reason we chose debates was because actually, as a social scientist, I don't think debates are a very good way of deciding things. Unfortunately, it's how elections get decided mainly, in that you are pushing both ends of the continuum. It gets very simplified, and the truth lies somewhere in the middle. So this book, and especially the chapters that I'm involved with in this book, because I was the editor, but also produced several chapters, one of which is crime control and due process, actually have a third section. Those ones, which are the key areas of philosophies of punishment, models of justice, that type of thing. And it's that third area that I'm trying to get to today, really, where that's why I've called it and/or crime control, because it's not quite that simple. And I've looked at the program, and there's quite a lot of coverage of these different models. So I didn't want to just tell you about crime control versus due process, but I wanted to really think about the issue that this event is really centered around, which is to maybe have a think about the developments of criminal law, maybe going beyond the idea of black letter law, and maybe having a synthesis at the end. It's good to have a debate to see where the boundaries lie at the ends of the continuum, but it's not always very good to stay just there and decide on a winner. There usually isn't a clear winner. I think we've got this last point here. I've taken this from the conference program, but the legislatures too have been unguided in their zeal to enact or reenact criminal legislations. And we could say the same thing about, I'll talk about England and Wales. An Indian audience will usually understand the difference between Great Britain, UK, England and Wales, which is the bane of our life if you live here, because it's very difficult to explain to Americans, China, etc. But hopefully that distinction is clear. I'm only really dealing with England and Wales law, which is the majority of the population of the UK or Great Britain. So in order to shift the pedagogy beyond the traditional paradigms, I was thinking about what the audience might be. I understand from Ankit that it's quite mixed. It's not just law students as such, but criminologists and different disciplines. So hopefully this will feed into multidisciplinary thinking. Okay, looking at the program, as I said, overlaps especially with all of today's sessions, and especially session 1 of day 4, which is has got Professor Bajpai and also Ankit talking about what the other models that came after crime control and due process. But as a fundamental starting point, we still have it, and as I'll argue, I think that largely the criminal justice system or set of processes is still more or less where crime control and due process arguments start and finish. I'm not sure the other models have made too much of an enclave. I think that the bureaucratic efficiency model tends to fit with either process. So this is another way, but I will leave that till tomorrow and the other presenters and not try to cover too much ground that covers the same ideas. So the first thing I think we need to think about from a multidisciplinary approach is how did we get here? And I mean, as the way we teach it, I mean, if you go back 300 years, maybe to the century before that, you know, just as the British, if you like, were arriving in India, the East India Company, etc. If you go back before that, you're pretty much into what many criminologists refer to as the period of barbarism. Now, what they meant by that really was mostly the way that criminal justice worked, but particularly in the punishments, which were all about doing something nasty to your body. And we have Foucault and everybody else that have written extensively on that. But it's really thinking about, we're really only still the icing on the cake in terms of how recent in human history terms modern criminal justice actually is. And in criminology and a lot of criminal law, and especially in former colonial English and Welsh environments, including India, we tend to have this Western model, and English-speaking criminology is very often based on this model. And then we have this continental, we call it continental because we can't quite admit that we're in Europe, and so the continent is over there. But what they mean by continental is usually German, French, Scandinavian, and then Italy, Spain, etc. They all have a very different system where the prosecutor is very powerful. I'm only going to focus on the adversarial system, which you pretty much have in India, and we have it here, and there's a connection there. So I think I won't cover the inquisitorial system and issues there. I will mostly limit myself to an inquisitorial base. That's wrong. It's adversarial. I should have changed that. So I think in that system, my animation won't work because I have to use it this way. But I think from a very short conversation with Ankit before to make sure our system worked, I think India got to having an independent or at least some type of prosecution service before we did. So our old system used to be that the police investigate, they do the prosecutions and present in court, prepare the case, and then they go to court. We now have the Crown Prosecution Service that's replaced this, but it's very weak still. And it's been around since 1986, whereas I think in India, roughly equivalent from the conversation I had is about 1973. I purposely didn't read up any more than I already know about Indian criminal justice, which isn't an awful lot, because I think you're going to know a lot more about that than me. So it's really thinking about what I could bring to the table in terms of where we've got to in England and Wales and some of my comparative research, and seeing whether it it rings any bells with you, strikes you as something useful to follow. So not all of my things will be useful to you, but I'm hoping it will provoke some discussion beyond just the lecture. We're very big at the moment on decolonising the curriculum. So in higher education, very much thinking about why are we presenting things in a particular way? Do we question, is it biased? Are all the examples we use, based on that kind of history? We're thinking, about decolonizing the police, defunding the police in lots of other ways. I'm wondering about whether there's any discussion in India about demilitarizing the Indian police, and I'll explain what I mean by that in a moment. But there's lots of discussion here now about the UK police militarizing, so becoming less of a civilian force than they were and more militarized. Now, the reason I'm saying that is because in this country, or Britain, in all of the Northern Ireland is a completely different case, but it was very important that the police were a civilian organization. There was lots of arguments about not having troops on the street, not having a military presence on the street, and it had to be a civilian one. I mean, that's because we had terrible events like Peterloo Massacre and all sorts of other things where the yeomanry were killing people. Mostly, I just want to get this in because I have a Scottish colleague. Mostly, the whole world refers to the first modern-style municipal police force into the modern era, founding the Metropolitan Police Act of 1829, London only at that point. However, I did want to point out to an international audience that actually my Scottish friends have said that's not true. The Advertising Standards Authority ruled it, so it must be true, and that Scotland had it first with the Glasgow Police Act of 1800. So modern style policing essentially has been around since only 1800. If you look back further, the whole issue, as you've seen on the slides above, it was around most of the debates about actually forming the police and having the police were about increasing urbanization, increasing problems with peacekeeping. And although we always talk about law and order, you'll see any of the basic texts about policing it's the other way round. It's really mainly about order and applying the law if necessary, which isn't always strictly possible. So we have law in the books versus law in the street, very famous dichotomy. Bittner and lots of police, police studies was where criminology sprang from. American police studies, really modern criminology in the English-speaking world. And within that, you have to have police discretion. And we know that the police as an organization are odd in that normally as you go up a rank structure in any organization, you get more discretion to make decisions. In policing, it's the opposite way around. So it's the constable on the beat that has to use discretion the most. And the problem is with that discretion, if it's not even, then it becomes discrimination. So not applying the black letter of the law can actually be a problem in that sense. Okay, so this is what Bittner said. And I mean, I'll read it out in full because I think this is where this is where I suppose we start to get to the grist of the matter, because it may be that criminal law and maybe criminology are not that important in terms of reducing crime or making it a more crime-free society. But in terms of where the law gets applied at the coalface, if you like, it says the search for a proper authorizing norm for the police, the representative of criminal justice to the population, led to the assumption that criminal code provided it. Now, criminal code is an American expression. It's more a continental expression. We all know India, like England and Wales, doesn't have a penal code system. It has a case law system, which causes its own problems. But anyway, the criminal law, that could be interpreted as. Bittner says, I have argued this is a mistake. Criminal law enforcement is merely an incidental and derivative part of police work. So the early police studies expected that you would go out on the street and see the police apply the law. And actually what they found, and Michael Banton, Professor Banton, who was my professor when I did my master's, was the first one to do this in England or in the UK, but it did it in England, and found they were all largely surprised that the police spent most of their time avoiding actually applying the law, which can be sensible, can be discriminatory. So their larger duties, if you go back before that formal, for the formation of formal policing from either the 1800 or 1829 onwards, the peacekeeping was much wider than criminal law. And if you look at the types of people that were employed, they were responsible for all sorts of things: fire, sweeping the streets, sewage, all sorts of other things that were just generally service orientated for the community. And keeping the peace was part of that. Okay, disturbs the peace if your sewage isn't working, also disturbs the peace if people are getting drunk and fighting and brawling. So the rule of law has always drawn part of its strength from this pretense, but I don't think this pretense is entitled to immunity. So what he's saying really is, how far does criminal law actually affect its application or lack of it on the street? And is there a bigger agenda? So that's the starting point I'm thinking of, really. So demands on policing, which feeds through into what criminal law is supposed to be applying itself to. We have the quotidian, low-level, high-volume public safety order, and this is the thing that people worry about. So if you go to Japan, it's always referred to, which I know a lot about, really, by now. It's often, or it's nearly always referred to as a low-crime society, and this is because it's low crime in terms of the crimes that we worry about, which are these, including, say, burglary. So you want to be able to walk around, not be abused. You want tidy streets. You don't want rubbish everywhere. You don't want broken windows. You don't want people fighting, shouting, swearing at you. So this gives you the sense of ease that you have a nice community where all those things are missing. Now, Japan, if you've ever been there or you ever go there, you will find is very like that. So it's a very nice environment to be around. However, if you talk about electoral fraud, government contract frauds, Yakuza, Boryukudan, then it does have a lot of crime. It's just not the sort of crime people spend waking hours worrying about. So the policing is about, again, more about maintaining order, and that's as people perceive what's happening with crime, than it does in terms of applying the strict letter of the law. However, the other end of that, and it's very controversial here at the moment, is we have the right to protest, to form in big groups, which can be peaceful, but they can turn into riots, insurrections, mob rule, or whatever. And then we also have this idea of investigation, detection, apprehension, and formally prosecution as well. So the police, as the public representative of, very visible representative of criminal law, have mainly these three functions to carry out. The issue with criminal justice, often call it criminal justice system, is it was never designed as a system, and the police have to fit within that. So they're actually relatively new. They're all established at different times and have evolved both within themselves and between themselves as well. So we've always had courts, even in the barbarous times. We've had something akin to courts. They've had to evolve a lot. I've covered barbaric punishments of the body, etc. But also you had some sort of financial penalties. So all of those are very old and have evolved. They've been around a long time. If you speak to most of the public, they see prisons as the backstop to punishment, that they've always been around, but they haven't. We know that prisons, not so distinction we tend to use it in criminal justice. I mean, jails are what used to be around. In other words, small places where you were held before something much worse happened to you. So we didn't have the Romans, the Greeks, all the great empires You won't find any maxi prisons in any of those, India included, in any of those civilizations, because they weren't prisons in the sense of as punishment as we have them now. They're really only a very modern development as the punishment, as opposed to a holding facility, a custodial facility before. So we've got rid of the death penalty here. There's no transportation that followed on. So you couldn't be sentenced to transportation. A lot of them went to the USA, as it now is, from the UK, but Australia is the example often used. But any of the colonies where they needed work to be done. And very easy to take someone to Australia in those days and just more or less, they weren't set free, but even if they escaped, it was very hard to get back or run away anywhere in the conditions at the time. So prisons, again, are quite new in terms of a system that you've got, but are the reference point for most discussions about punishment, most discussions about what criminal justice does, as we'll come on to. Probation, community service, I'm not sure, I don't know anything about that in India, but in terms of how old it is, it's very new. It's into the 1900s, just into the 1900s. Sprang out of the police missions to the courts. So in other words, it was about alcohol related, temperance, that type of thing, seeing the same people arrested again and again for petty offences. Moving on to other types of things like community service, it's very new, but far more people are sentenced to this in England and Wales anyway than they are to prison, but it's almost invisible. I know we've got some sessions on forgiveness. I'm not sure how far they're going into the restorative justice approach. I'd be surprised if they didn't, so I don't want to overlap too much with that, but also very new. And then we also have other agencies now which are talking about diversion, so in a way to avoid involvement with criminal law. And it's, so there's if you read Niels Christie or whatever else, they're both very old, because you have the panchayat system in northern India anyway, at least I think, which I'd know a little bit about. Very old, and also some new ones like sentencing circles in Canada, etc. And there's New Zealand Maori ones as well. So I think, although we feel we've developed in criminology, I think if you think back about what the criminal justice process or processes are trying to achieve, it's still very, the criminal justice system is still very classicist in its overall approach. So it's designed around what Beccaria and Bentham and Ferry to some extent. So they have that old-fashioned idea that you're assuming that the individual you've got before you in a court has free will, and they've made a rational decision to place pleasure above pain, the hedonist principle. And the law itself, criminal law, whichever way you look at it, is really based on deterrence, which is really, Beccaria was the one that really did most of the running in looking at the theory for deterrence. And then if you are so that's the forward-looking part of the law. And then if you're not deterred, you failed in your self-control, your rational self-control about you want more pleasure and you wanted to ignore the pain that would come, then you have to punish people. And then punish, as we know now in modern criminology, can mean a number of things, which we know, but politicians and the general public generally don't. So if you say deterrence is a theory of punishment, or is a part of the theory of punishment, they'll say, well, that's not punishment. Rehabilitation, well, that's not punishment. With our system, as we'll see, all of these things are things. So if you have to do a rehabilitative program, that's your sentence. You are coerced into it, so it is a form of punishment as well. And then, because you're focusing only on the crime aspect of the events, the big criticism, as probably a lot of you will already know, is that free will is, and it being a rational decision, is great if you have money and accommodation, and you don't have any other pressing issues in your life. If you have children to feed, and you have no money and no food and no accommodation, it's not quite an equal playing field from which to make rational decisions. It also, and then the biggest issue we have that criminology never predicted, social science in general never predicted, was the post-war boom in drugs and problematic drug taking. So once you're taking drugs or you have a lot of alcohol in your system, which is much older, your rationality is not really quite the same, and your motivation, and so you have bounded rationality. Then it makes sense to risk a lot more to get your pleasure if you're addicted. So we have rolled these into our system, if you like, with looking at aggravating and mitigating circumstances. But at the base of the criminal law, we still have this mens rea, you know, and it's always, I mean, discussed now, putting things in. I think you have the same a history in India. I was listening to a program a while back, but, you know, we have Latin as our base here. And I think not particularly with the law in that sense, but you have the classical Sanskrit was used in India, and it's only getting rid of this in various aspects of cultures that allowed things to modernize and move on. Our law is, I mean, is full of Latin phrases that I don't think the Latins, so to speak, the Romans ever used. But you know, you can and medicine as well. So it makes things sound more official than they are, or confusing to the public, and you have to pay somebody to tell you what it means. But at base, we have this idea of you know, the criminal mind, if you like, as it's sometimes interpreted as well. So also, I think when we're talking about criminal law, we're also nearly always assuming it's the adult system. And of course, that's because a lot more people go through the adult system because there are a lot more of them. And also on serious cases and cases that might go to prison, which is kind of ignoring, really, on a proportionate basis as a social scientist, most of what criminal law application is doing and is about. So we're not really considering, most of the time in our discussions, and the back of our mind, we've got this model, and we don't really think about high volume cases, the day-to-day drudge that the police spend most of their time doing. No great mastermind criminals, just annoying nuisance a lot of the time. I mean, it's not to trivialize if your house is burgled. But diversion and treatment on a wider welfare base for youth, and thinking about youth justice, is more logical, preventive, and happens a lot more. But we seem to regard youth and youth issues, youth justice, as a kind of sideline, a sideshow to the main adult, circus, really, almost. And I think that's probably quite flawed thinking, because if you don't work at the youth stage, it's very hard to intervene and change things around at the adult stage. So there's this bias towards adult and seeing youth justice as a separate, a completely separate track. And I think those need to be thought through and combined better. So most of you are probably, from looking at the program, I think most of you are probably already aware of what the crime control model is, based on the concept that repression of criminal conduct is seen as the primary function of criminal justice agencies. So not necessarily the criminal law in that sense. So that order is maintained, there's that word again, order, and citizens do not live in fear. Like I was saying, in Japan, they largely don't, but it's order. As a consequence, it's accepted that some mistakes will be made and the innocent punished, but that this may be a necessary price for the greater good. So a utilitarian argument, again dating back to classicism. And there's an assumption there that the mistakes are tiny and mostly a success. So you're prepared to take that hit. Okay, you'll all be aware that the due process model is the other end of the scale, so that it presumes that you're going to go all the way through the process. It's a formal, adjudicative, adversary, fact-finding set of processes in which the case against the accused is tested before a public and impartial court. Now, most of the cases never get there. The serious cases, not all of those get there, but most cases may be dealt with on the street, may never go anywhere else. And in fact, now we have a lot of out-of-court settlements, which our magistrates are a little bit unhappy about, where the police can give you an on-the-spot fine for lots of different offences. So the idea that you need criminal law, I mean, they have the power to do it through police powers, and that's criminal law, but a lot of it isn't going to court. And the due process model is really based on the idea that it's a case that will come to court, and then how you actually process it. So there's a lot missing between those two models. I normally ask at this point who's preferring crime control and who's preferring due process. I'm not sure how easy that is. We could take a rough hand count, but I think I'll let you just think about that yourselves. You know, on balance, it's you could interpret this two ways. You could say who thinks it should be about crime control or due process, criminal justice or criminal justice process and the criminal law, or you could interpret it as what do you think actually happens. So I would say on the latter case, I think we're largely about crime control in terms of the criminal justice agency's operation, and particularly the police, especially if you have lower resources and you're spending your time fire brigade policing, as it's called. You're going out to crime that's happening and trying to deal with it rather than preventing it. So I won't ask that question in quite that way today. But have a think about where you think that balance lies in application rather than morally and theoretically. There's not a clear balance there. So the issue is, we know there's a lot more models, okay, but a lot of them presume you're going to go through the process. So I will let the other sessions, if you haven't already, and then tomorrow's session as well, you've got lots of different models coming. So I'm not going to overlap too much with there. But I think what I'd like to sort of raise really is the fact that depending on which of these agencies that all started up at different times with different missions, they have different goals and rewards. So you're, depending on which agency, criminal justice agency you work for, you're more likely to see the purpose of criminal justice and therefore criminal law differently. You will rank what you're trying to do with criminal justice differently. But there's some quite interesting patterns within that where you get some commonality. So as a social scientist as well, I start to think about processes and outcomes, which over the years is not something that I think lawyers, solicitors and barristers as they are here, but lawyers as a collective term, have always, in my view as a social scientist, have a clear distinction between. And in fact, many languages, efficiency and effectiveness, they're the same word, whereas they're really not in terms of if you're trying to change things or improve things. So if you're the police, you will have process measures. And I know you've got a session on arrests, etc., and charging. But so a process measure, if you go out now, we have, well, how many people have you arrested this month? How many of those have you converted into a charge? We have these detection, they're called detection rates, which kind of, I think, is a bit of a misnomer because it makes it feel like you've solved the case. I know it doesn't mean that, but it just means you've recorded it really as a crime, you've attended. So if you're arresting a lot of people, converting a lot of those into charge rates, then you're doing quite well. But that doesn't tell you what impact you're having by doing that. So if you're looking at but they are easier for middle managers and senior managers to focus on because it looks like you're being successful. If you look at the outcome rates, they're harder to achieve. In other words, have you brought crime down by doing this? And your prosecution rates, which again, I think are not really an outcome, but they're part of the process, are not in your control anymore, completely anyway, because you're reliant now on the Crown Prosecution Service agreeing that this case is strong enough to go to court. It's rather about second guessing. So the Crown Prosecution Service will say, if this doesn't have a 50% chance, at least a 50% chance of success at court, then we don't think the evidence is strong enough. We're not going to send it to court. Whereas if you speak to the police, they say, well, I think it should still go to court and see what happens. And they argue about the evidence. So there's quite a lot of tension there. But even saying it's good enough to go through to court, that might be seen as an end in itself in the Crown Prosecution Service. They've limited the number of failed cases, and they've got to measure that. But it's not really telling you what you've achieved in terms of crime reduction, crime prevention. Most criminologists don't like crime control as the end of the spectrum that they think is not really acceptable as an end in itself for criminal justice. It's obvious. So if we look to recent examples of where order, big scale order, we've got Belarus, where half of my family were originally immigrants from into this country. And then currently we've got Almaty in Kazakhstan, where the civilian police stroke military police are on the streets and killing people. Not what we want in modern democracies, and you don't have to worry too much about due process within dictatorships. But we still have these kind of scenes here. Public opinion is harsh on a government or a local police force or local politicians, mayors of London, etc., if they lose control of the streets. And in fact, this is an old concern. If we look at Section 5 of our Public Order Act, it's very rare that something like this, where you'd say, well, that was obviously a riot. It's very rarely taken to court as, in fact, I can't think of an example in recent history where it's been taken to court as riot, which is the highest end of it. Because within the law, and this dates back a long time, is if the police charge people with riot, the police are then liable for the costs of sort of compensating for the costs of that riot. And the implication is that criminal law was designed to say, if you lose control of the streets, you have to pay for it, which is not really very practical in today's terms. But there's a whole issue about the fact that the police will not go for the top level, and it was a charge, and it was a way of saying the police do not lose control of the streets, and it's an incentive to make sure you were competent at restoring order. So we do have processes that are due processes. After that, it may be that it wasn't very clear whether the law was being applied well, but order was restored. That's your first priority. And then you've got to decide whether that action was legal. What about volume crime, though? Because we don't have riots all the time. We all have them. We all have incidents that aren't particularly riots. It could be terrorist related, etc., where you've got to restore order. And people expect that. So on that level, not many people will argue about those cases. But the point is those cases are rare. So they don't apply to most of the time when you're trying to apply the law. I think where the rub comes is with the volume offences, because the traditional processes that we have are simply not designed for the level of people going through them. We now have, after New Labour, we now have many, many more offences. Therefore, we have more crime. And to process them through our magistrate system, even, the cost is too high, it's too slow, and they don't have the resources. So it comes to the point where people are saying we don't have justice. So in theory, it's great going through all those due process stages for each offence, but the system is creaking under that. You simply don't have the resources, and if you do provide the resources, you will have more offences. So just pushing everybody for relatively trivial crimes through the criminal justice or criminal law process is probably not very feasible and not the way to go. Other things that I think impinge on this is we had a sort of really largely a bit of a failed attempt to draw antisocial behaviour, low-level antisocial behaviour, into the criminal process via a civil law application, and then if you breached it, you became criminal. And of course, could that have been dealt with in a different way? But the issue that Louise Casey, the Asbozar, was always drawing up is the law is made by people who don't live in those areas where this is a problem. And I think that's where you have a major tension between this traditional processes, which don't address the immediate issues that people have on their doorstep. We all know also that a very small percentage of reported crime comes to court. So I've just done, I've just pulled this in as roughly equivalent, but it can be as small as this, or it can be as big as this. But the green bit is the bit that doesn't go through the process at all. So it depends on which figures you're using. We all know there's lots of filters for police recording, charging, case progression, etc. Cases often dropped and victims let down. So we're right in the middle of this argument at the moment. So is the criminal justice process, crime control isn't working, due process isn't working, so we need a rethink. If we look at, I'm not sure how big that is on your screen, but if we look at this, most of it goes to the magistrate's court. We have about, this is not 2016 because I haven't done this again since, haven't had to do this again since then, but it's roughly going to be where we are, about 4 million offences. Not many go through the Crown Court, and most of them go to the magistrates, and it's about a third of cases that are reported, reported and recorded. So if you look at the British Crime Survey, now called Crime Survey of England and Wales, then it's much bigger than that, way bigger than that. If we look at what happens to those people as a result of going to court, I know this looks very complicated, but it's never done in the way that you need it, but it's 72% of the outcomes of all of these, Crown Court, yes, the higher court or not, it's about 72% of them, these cases are resolved with a fine. Not very interesting, not very exciting. 13% of them are those community penalties, probation plus, and only 7% are sentenced to custody. Yet the focus is really always here because it's more interesting, more exciting, more serious, but not representative. So criminal law, I think, is very, very biased towards this minority of serious offences, and so is media pressure. So very quickly, I think the pressures on the government and lawmakers tend to be those things: an assumption there's a law-abiding public, victims need protection, keeping order on the streets, locking away offenders as long as possible, and you've usually got this mixture of these three key philosophies that combine for crime control, some of which are mutually sort of antagonistic if you're a pure retributivist. But you've got deterrence, as I mentioned to start with. If that fails, you have retribution, and it's very hard if you're sending someone to prison to not also incapacitate them. But if you put them on a community penalty, there's arguments about how much incapacitation that actually affects. But think about, is there a big majority of law-abiding citizens, or is that this classicist assumption? If you read, I've put that one in there, if you read The Moral Economy of Everyday Crime, again, it goes back to what sorts of crime you think are real crime. Most people are offending at some level, but it's usually crimes that they don't regard as real crimes, but in fact are. So what does this say about the purpose of criminal justice and in whose interest it functions? Although this is, you probably will be familiar with these philosophies of punishment, but and these are the ones used by the Halliday report, which I've put the link in for there. But the interesting thing about this is that, just very quickly, if you rank what they did, and they used it because it's a government report, they've ranked the 7 purposes of sentencing based on those philosophies, changed the wording. So that's why I've put the original kind of wording at the top. But it's very interesting how, if you look at most of the professions think that rehabilitation, which is this column here, is actually important. Maybe the police a little bit in the middle. Okay. But they also think mostly that punishment is important, and that probation officers are the highest. Then, by that they mean retribution. So if you look at that, most of the arguments of do you do one or the other, if you look, most of the professions want both together, not one or other. It's a bit the same crime control due process. The other side of that is most of them don't think deterrence is actually the purpose or isn't happening. You could interpret either way. So down this end, this is what the arguments tend to be about, whether you should be doing these things, but actually most people are focused here and here. Now, if you look at what the public think, they've done it in a slightly different way. They think very similarly in a way, but change the offender's behavior best. They think deterrence will work, which the professionals who work in the industry don't. And there's not much about punishing there. So they're less punitive than the criminal justice professionals. However, when you look at what they think will be effective, it's always prison. Okay, prison and supervision, which most people don't get, and we know doesn't work very well in that way. And then probation and community sentences are lower down. Okay, and what's worse is if you inform the public, that means give them more information about cases, they actually think it makes their opinion of prison go up, which is so we have to deal with these odd ways. Apologies for have to paste them in like this because the Holiday Report is horrible. It's quite old and it's quite horrible to copy things from. So it depends on making deterrence work, but in a nutshell, you can't make it work. You can make all of these things work with criminal law. So you need certainty, celerity, as it's often called from the Latin. So if you commit an offence, you've got to be certain you'll be apprehended, that it will be done fast, and that the punishment is proportionate to the crime. Or there's other ideas since Beccaria saying, overwhelming kind of punishment. Can the law or the whole criminal justice system deliver this, given that most of it doesn't get either reported or recorded? And therefore, will it reduce future crime? So you must be able to change the social and economic circumstance of offenders, even if you get those three things right. And we're not doing that. And I don't think criminal justice and criminal law alone will be able to do that. So I'm aware of the time now, so I'll try and just get the last key points in. So we've got the slow process. People, especially criminologists and magistrates to some extent, think speeding the justice system up can be worrying in terms of affecting human rights badly, but no one cares about traffic or speeding violations in that sense, which is a massive volume that goes through with no trial. We do have new technology to improve existing processes. Witnesses appearing via video link saves a lot of time and expense. We have body-worn video camera footage now accepted as evidence, which then creates can technically create a much faster process for the patrolling police, not actually for the processing police. But that's kind of improving the system we have. But I think you need to think outside justice for some solutions. So look at youth justice approaches is what I would say. I mean, India probably, I suspect, has all sorts of useful and innovative approaches that divert youth from going to the criminal justice system, but I don't know that. England does have a few. Wales has gone the whole way down the process of diverting nearly all young people out of the justice system. And we also have this issue now about the 18 to 25 age group, neurological evidence showing you need to take a different approach with that age group. That's not the same as young offenders and not the same as old adult offenders. Won't go through the specific cases because we don't have time, and perhaps you can look, well, obviously you'll get the slides. So I suppose the lesson that I want to push is if we ignore social and economic circumstances, we can't make deterrence work, we can't make criminal justice work. We're only dealing with a small proportion of crime that happens. So are we happy with a process-based approach, which any medic will tell you? I know a lot of doctors done stuff with mental health research quite a lot recently, and they always term this as the operation was a success. They sewed up the patient again, but the patient died. And that's pretty much, I think, where we are a lot of the time with straightforward applications of criminal law. We're getting the processes through, not even particularly well, but we're satisfied at the end that we've done the right thing according to the process. But the problem is, where did it get us? I know you've got restorative justice coming through. I'm a little bit skeptical, a bit controversial about its application. I think it can work, but if you look at the sentencing circles of the gacaca system from Rwanda, panchayat you have here sometimes used, not always a great lot of evidence that it works terribly well, that it's not always really actually restorative justice as it should be. And I think from our experience, women don't tend to do so well out of that, because they're saying people in those in the circles, sentencing circles in particular, were part of the problem, and they were all men. So, I mean, I'll leave that to you to debate. So the key theme of the programme: legislature has been unguided by their zeal. I think you can't legislate away crime, because you can't make the criminal justice system or set of processes effective enough, efficient or effective enough, to actually detect crime. There isn't the certainty that you'll get caught. It's too slow, and you miss most of it. It's frightening, although it doesn't stop governments trying to do it. The first thing they will do is say, well, let's have some tougher law. There's no point making the law, criminal law, tougher, increasing the sentencing, if there's not much chance of catching anyone or enough people for doing it. And then it's too slow when you do catch them. So have a look at other countries. I quite like the Japanese system of sending people out to look at what other countries do, but the problem with that is the outcome from that isn't always what I would have expected. But the overlap is always higher than you think. Also, think about what India does best. Looking at the figures quickly, I said I wouldn't look, but I did. Low prison population, which is usually because a low prison population isn't always a good thing. If you look at China, it's because much worse things happen to people. The prison population is kept low. India doesn't use prisons very much, and it also has, although it has the death penalty, it's very low. It's almost a sort of unused, anyway, sorry, I forgot. I can't access the word. My COVID's coming back. Also, my son works in mental health. Lots of positive stuff coming through about how India can deal with mental health. But again, can we use that? Can we import that sort of process in, different to a Western approach, but proceed with caution, because the resources aren't there, and most people still are excluded from that process. Legal precedent I'll finish with. I think science is coming in now. We have this fight, freeze, or flight syndrome. We forget the freeze bit. Lots of neuroscience evidence that women are more likely to freeze in a rape situation. Looking at the cases, so I know there's a lot of the coverage of feminist criminology a lot here. There's lots of different feminisms, I know. Some of it against empiricism, but it seems to me a lot of where the feminist critique goes is supported by neuroscience, and yet and against the traditional relying on the typical arguments about the woman didn't fight back in court, which is still used here, and cases fail because of it. And there's a lot of synergy between those two things that isn't happening. So that's a good place to look. And I also think lawyers, some of you may be, need to work with social scientists, which some of you may be, and all those uniquely different cases that work through case law really are not that unique when you look at them in aggregate in terms of what you're trying to achieve. So maybe look at Journal of Psychology, Crime and Law and trying to marry all of these things up. And I know I've gone a little bit over time, but I'll stop sharing that now, and hope there's time for some questions. Thank you.
Thank you so much, sir. Now this floor is open for discussion. Since we are not left with much time,
I apologize.
So I request the participants to keep their comments and questions short. So whoever is willing to participate and ask question, please raise your hand. I will call out the name one by one, and he or she can unmute herself or himself and ask question. Okay. So first, Marisport, please go ahead.
Yes, yes, thank you. I hope I am audible, right? Hello, am I audible?
Hello, yeah, I can see your name,
Yes,
Marisport.
yes. Thanks, Professor, for that wonderful session. Actually, my question is relating to that classicism principles which we are deploying, and especially it is actually affordable for the government to deploy. But my concern is how we can use it for curbing or controlling the criminals who are having bounded rationality, especially white collar criminals. They may have political nexus, or sometimes they know they have their own companions while committing the crime. So how to use that conventional classical way of imposing punishment to control or curbing these criminals? What is your views on this?
Well, I do think that deterrence will work better. I mean, if you look at if you read a lot of textbooks, to be honest, it will say deterrence doesn't work. You know, and you can see from the reaction of the criminal justice professionals that they don't think it works either. Well, I mean, deterrence doesn't work, unfortunately, with a lot of criminals. It does work, for instance, with students. If you know you're always applying these penalties, most of the students get over that line or suffer the consequences and then don't do it again. I mean, we did experiment with things like stopping police officers, professionals being racist by docking their pay. You know, if instead of sacking them or suspending them or whatever, that's 10% of your pay disappears if you do. So when people have a stake, it will work quite well. And of course, if you think back to the Beccaria, Bentham, they were middle class to upper class people in very comfortable positions, looking at old Spartan philosophy, Spartan situations, and all the rest. So it will work with those populations. The problem you've got with fraud and that type of thing is it's very complex. And I think if you look at the work of, it might be Martin Kilias in Switzerland, I mean, the balance, you haven't got the balance right there, because if you do massive fraud, salt away millions of rupees or pounds or whatever, and then you're prepared to do 3 years in prison. The sentencing has been traditionally quite low because people don't worry. It doesn't affect most people, or they don't see it as affecting them. And then you've got a lot of these ex bankers, etc., who've done that, salt away the money. They're quite prepared to do their 3 years in prison and then disappear, and nobody can find the money. So I think it will work with that population, but you have to make it effective. And I think that's where criminal law could work quite well, but it needs to be integrated in terms of what will work for deterrence. So if they're coming out of prison and they've no money, and they know that deterrence will work. But where you're a drug addicted, a heroin addict who thinks it's sensible to go into a department store, 5 of you go in, you steal some goods, you all run out the entrance, and you know that 2 or 3 will get away. That's your rationality for that day. Then processing that through a court and punishing and putting them in prison where they can still get drugs is not really actually affecting, it's not effective. And I think that's where it's applying, it's thinking about how useful is the criminal law process, whichever model you're using, really. If it's criminal law process, is it sensible to go in that direction for volume crime, which is what sucks up your day-to-day resources? So I suppose that's where I am with that.
Thank you, Professor.
Thank you. So any other questions? I'm glad I didn't leave so long now, because
so Professor Tom, I think there are a couple of questions in the chat box as well.
Oh, let's have a look. Yes, I'm not so familiar with this program. Right, so
we have Dr. Kalpana Rani, who is asking, do you think deterrence works as a preventive factor in crime commission?
I think I've probably answered that in terms of, I think it will work for certain crimes if you're sensible about the law. If you can't enforce properly, and so in other words you can't catch people, and then the sentence is too mild, then it won't work. But I think you can make deterrence work in those situations. Whereas for volume crime, most of the time I don't think you can. I mean, if alcohol's involved, if we're looking at using body cameras, for instance, police wearing body cameras does not act as a deterrent to drunk people because they're drunk, so they're not rational. But what it's great at doing is providing the evidence saying, no, the police didn't break your leg. You broke your leg by trying to kick a police officer. You were drunk and you hit the traffic bollard instead, and it broke your leg. So it's great for the prosecution, but you haven't solved the problem. So I think it's dealing with it's this low level, high volume, slow process that's not working, and the deterrence won't work there because offenders are not rational in the sense that nice middle class people or upper class people like Beccaria wanted, and they have other pressures in their life which are not really criminal justice or criminal law based. That's not their thinking. Also, most of the time think they won't get caught. So you're not able to, on that low level, high volume area, which criminal law doesn't spend a lot of time, so much time thinking about. It's not working. I think that's what I'd say with that. Retribution and rehabilitation can work as an effective. Yeah, well, I think they can work. So there's primary and secondary and tertiary prevention. So the tertiary prevention is you've already committed the crime. So retribution and rehabilitation are only tertiary prevention, just to stop you doing it again, which we still don't get right if you look at prisons particularly. But I do think there is an issue. There is an issue about if you put people in prison, most of them are on short sentences here. So we've had the argument about put them in prison for longer and they'll get more rehabilitation. So you end up with this 3 strikes and you're out and you go to prison for 3 years for stealing a pizza or whatever it was, the famous example. But you're not getting rehabilitation there. And then you get an argument about put them in prison for longer, but you're still not getting rehabilitation. So we know short sentences, which is the equivalent of probation stroke, those community penalties, work much better, but you still have to get that right. So I think the issue about, I think you can, probation is a punishment, because you're coerced into doing it. You can't say, no, I'm not going to, and there are issues around enforcement if you don't do it. So it's what you want your retribution to be. The modern retributivists are saying it's proportionate, but they don't care too much about what happens after that. Whereas there's a lot of effort now gone into rehabilitating people, but you've got them. They're part of the retribution. And I think the problem with that is that they're always looking for a magic bullet. So, we've had cognitive behavioral programs, but, if you're sort of serving a 7-year sentence and you do a cognitive behavioral program in your 3rd year, is there much point measuring the impact of that when you're released, in prison? Whereas if you're doing it in the community and people are around, and you're having to use that in your daily life and you're on recall if you don't get it, then you're likely to. So it can be more effective. You've got the punishment and you've also got the rehabilitation effect. But simply punishment on its own, which is what most short-term prison sentences are, you lose your job. You probably might lose your, because we know that young men in particular, if they have a girlfriend, then they don't offend so much. Usually because the girlfriend doesn't like the jib of their friends and says, I think they're, and they start to hive them off. And then when they don't have the girlfriend, they go back to their own ways. So I think there's lots of ways in which you can manipulate an environment, push people down a path which is coerced. In other words, it is a sentence of the court, or it's a potential sentence of the court if you don't engage, say, with domestic violence initiatives. So I think they can work together. And I do think it might be controversial for the restorative justice idea, but that we have there's a program, I think it's called Acorn in this system, or Sycamore system, where you go to prison and you apologize and engage, you know, or you're on probation and you apologize and engage with the victim, seen as a better process. How proactive policing is working? Is it, well, the problem is with proactive policing is we've cut them all out of the budget, so we don't have the numbers of police to be able to do the community policing, you know, all the different versions of what it's called now. I mean, I think you know, you have to balance that against, we've got all the youth services disappeared, you know, so most of the youth activities budget has disappeared. So this is I think this is more of an economic issue. I think you can make proactive policing work. That can be crime control focused on hotspots and all sorts of things like that, where I've worked in that area before. But there's also community prevention and amalgamating the youth offending system with the police to not put people through the process. So yes, it can work, but not if you don't fund it. It's an interactive request to raise that. Oh, sorry, right. I think they've largely done that. So I hope I've gone 4 minutes over time, but I think I've got through the questions. I hope that's useful. I mean, I hope it's raised some issues that might overlap, so it might promote some discussion in other sessions. I'm sorry I can't attend. I don't think it's ever going to be feasible with Omicron. My university wouldn't insure me. And then I also got COVID last week. So despite the 3 injections, I wasn't very ill. So I wouldn't have been able to be there anyway. So I'm very sad about that, because it looks like a very well organized and interesting program, and I'd like to have taken part in other sessions as a listener. But that's all I can do. I hope thank you. I hope I can meet up with you at some point when I can actually come to India and actually finally, because I've wanted to do that for a long time, but I keep flying past it and going to East Asia. So I can come back. The time difference is not so problematic, is it, really? You know, compared to if you're talking about China or Japan. So I hope that has been useful. I hope it doesn't tread on too many toes of the other. I'm hoping it's some mortar to join all those bricks. Help a bit more mortar to join the bricks together. I'll send the slides, and then, you know, I'm hoping that we can develop. I didn't put a lot of detail about references and sources and everything in there, but I'm hope, you know, if there's any questions stemming from it, we could develop an area of study that would be most useful to you.
So thank you so much, sir.